are streaming. We're still waiting. Okay. Okay, I think we are a go. YouTube, you killed that mic. Everything should be live. Okay. Welcome, everyone. This is the Utah Board of Oil, Gas, and Mining, March 23rd, 2016 public hearing. We're now ready to go forward. Our first agenda item is docket number 2015-023, cause number S/049/0050 in the matter of the reclamation at the Elite Rock West Mine. We'll take appearances at this time.
Thank you, Mr. Chairman, members of the board. John Robinson of the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Anyone else here on this matter? Mr. Robinson, please proceed.
Thank you, Mr. Chairman. Members of the board, you have before you the final joint motion to continue in the Elite Rock West matter. I think this matter is somewhat known to you at this time. I think the filing provides a brief overview of why the division seeks to continue one last time. I've also brought with me a representative of the division, Ms. April Abate, and with your permission, I'll ask her to remind the board of her involvement in this matter and then give a brief update and then ask the board to grant the motion to continue. Thank you.
Please proceed.
Ms. Abate, again, I think the division, the board knows your position with the division, but just remind the board and then give that brief update if you would, please.
Well, thank you, John. April Abate. I am with the division in the Minerals Regulatory Division. I'm one of the inspectors in the group. And we've been working on this project for several years now. Late last year, the operator had agreed to proceed with the reclamation of the site, and it has been progressing. Just has been a bit slow, and that's really only due to weather delays over the winter. So he has since moved there was a significant amount of boulders on the site. He's moved them over to the adjacent small mine. The property owner owns the whole area. He owns the Elite Rock site as well as the small mine that's adjacent. So he's requested that those boulders be moved over to the small mine site. The former operator has done that, and he is now in the process of doing the regrading work. He's, I would say, probably about 80% of the way through on that grading. I am planning to do an inspection down there tomorrow to see the progress, and ultimately we'll finish that regrading work and then begin the seeding. So we're almost there, and that's been the reason for the continuances, but we're almost there with this one. We just need a little bit more time.
All right, thank you. Any further questions from the board?
Board members, any questions? Seeing none, back to you, Mr. Robinson.
With that, Mr. Chairman, members of the board, I move the board to grant this final joint motion to continue with the expectation that we will see final resolution of this matter before the April 27th board hearing.
Board members, you have a motion before you. Is it seconded? Okay, the motion is to continue this matter as Mr. Robinson just suggested. Any discussion? All in favor, say aye. Aye. Any opposed? Let the record show that it's unanimous. You'll prepare the, I think I just signed, pardon me, I will just sign the order. I have it.
Yes,
And
thank you,
so
Mr.
it's
Chairman.
now effective.
Very good. Thank you.
And Julianne, it's in this green folder. Okay, thank you. The second agenda item is docket number 2015-023, cause numbers S/0, pardon me. It is, correction, I read the wrong one. It is agenda item number 2, docket number 2016-005, cause number 222-16, in the matter of HINTO Energy. We'll take appearances at this time.
Thank you, Mr. Chairman. Melissa Reynolds for the Utah Division of Oil, Gas, and Mining.
Anyone else involved in this matter present? Seeing none, back to you.
Thank you. This morning, the division filed, and you have before you, a stipulation for judgment or dismissal and a motion to approve that stipulation. So I'm just here today to explain what the stipulation achieves and answer any questions the board might have. We also have John Rogers and Josh Payne here if you need to ask any questions of them. On February 24th, you'll recall that the division and HINTO Energy filed a joint stipulation and motion to continue this matter to the hearing today. That motion to continue required HINTO to complete a list of work on their 8 oil and gas wells. It also required HINTO and the division to negotiate and enter into a stipulation that would lead to either dismissal of this matter or automatic entry of judgment against HINTO. And the third thing that motion to continue required was HINTO had to post an additional $15,000 surety with their attorney held in escrow for the benefit of the division. So if HINTO did not complete the list of work or the two parties were unable to come to a stipulated agreement today, then we would have moved forward with the hearing. HINTO did complete a substantial portion of the work. They didn't complete all of it, but the parties were able to enter into this stipulation for judgment or dismissal that you have before you today. So I just want to briefly explain what the stipulation achieves. On the back side of the document you have a timeline. So I'll just reference that timeline in order to sort of give you a visual representation of what we're achieving with the stipulation.
Just a moment,
yeah.
Ms. Reynolds. Board members, do you all have the timeline in front of you? Yes.
Yes, okay.
Proceed.
Great. So the stipulation essentially goes through 3 different categories of wells, and you have 2 on this timeline right here. The first category relates to 4 different wells: 1401, Little Boy 2, Sweetheart 2A, and Sweetheart 1402 wells. Those 4 wells HINTO plans to plug. So the stipulation requires HINTO to provide plugging plans by March 30th, 2016 on all 4 of those wells. And then once the division approves those plans, to move ahead with plugging and restoring the wells. So that they have to have completely plugged and restored these 4 wells to the division's satisfaction by, you'll see, June 6th, 2016. So it gives them about 60 days after the division approves the plugging plans. The second category relates to the Sweetheart 5A and Sweetheart 7 wells. And this one's a little more confusing, but by March 30th, HINTO will provide their mechanical integrity tests and demonstrate to the division that these 2 wells have mechanical integrity. One has been shut in for over 3 years and the other has been shut in for over 10 years. But HINTO has the idea of putting these 2 wells onto a gas-to-wire cogeneration project in 90 days. So we've given them that option. If the division agrees with HINTO that these 2 wells have mechanical integrity, HINTO will have 90 days to either put the wells onto that cogeneration project or plug the wells if the cogeneration project turns out to be unfeasible. However, if the division disagrees that these two wells have integrity, HINTO is required to plug the wells by June 6th, 2016, which is that same deadline for the four wells that will be plugged. In addition to these two sets of wells, there's two other wells, the Gibraltar 1 and Nugget 14-4, which HINTO plans to keep on production. So this stipulation essentially requires for those two wells and all other wells continued production reports every month, even if that production is zero. HINTO will provide those reports. The final thing is that HINTO must, by March 30th, provide sundry notices on all work that has been completed on all 8 wells since HINTO took control of these wells in March of 2014. The division has not received any information as to what work has been done, so they're curious and need to kind of keep their records up to date as far as what's been done. The final point I'd like to make is just the end result of this stipulation. As I mentioned in the beginning, it will either lead to a dismissal of the matter or an automatic entry of judgment from the board. So first, if HINTO meets all of their obligations laid out by the stipulation, the matter will be dismissed. In that case, the division will seek an order from the board dismissing the matter. However, if HINTO does not meet its obligations, there will be a judgment automatically entered against HINTO without further hearing before this board. In that case, the division will seek that order entering judgment against HINTO in accordance with the stipulation. And that just means we will seek an order that forfeits the certificates of deposit and that $15,000 as the remaining surety, and proceed with the division completing plugging and reclamation of these well sites. That essentially covers the main points of the stipulation. Again, I am here to answer any questions you might have, as well as our division representatives.
Does that conclude your remarks?
It does.
Board members, any questions of the division? Go ahead.
What is the nature of the integrity testing that's being proposed, and what is the likelihood it might lead to an ambiguous answer that would be contested?
Can one of you answer that? I'll let Mr. Rogers or Mr. Payne answer that question.
Have our petroleum engineer, Dustin Doucette's been involved with that.
It was fun to watch you jump up, Dustin.
I knew I was in trouble. So I think they've already performed on the 2 wells. They've already performed the mechanical integrity test. They ran in a hole with tubing and packer and pressured up the backside. And from the reports we got, both those 2 wells did pass the integrity test.
Is gas to wire? We've never heard any reports of that being economic. Are they serious?
Well, we raised that question also, and so we thought, well, rather than condemn them right now, we'd allow them the opportunity to do this in a 90-day. They think they have the ability to gather enough gas down there and do that, so we're anxious to see what their outcome is, but we are watching it and have questioned that.
Other questions? Seeing none, Melissa, will you suggest a motion?
Yeah, so now, Mr. Chairman, members of the board, the division would move this board to approve the stipulation pending the division providing notice to the board on or before July 5th, whether HINTO has complied with the stipulation or not.
Is there a second to that motion? There is a second. I think you just heard the motion. I don't think I need to repeat it. All in favor, say aye.
Aye.
Any opposed? Let the record show that it was unanimous. Thank you very much.
Thank you.
We are now at agenda item number 3, docket number 2016-006, cause number 166-08. Regarding the matter with CCI Paradox Upstream LLC. We'll take just 1 second here. Okay, we'll take appearances of counsel.
Brett McDonald of McDonald and Miller on behalf of CCI Paradox.
Melissa Reynolds on behalf of the Utah Division of Oil, Gas, and Mining.
Anyone else present involved in this hearing? Okay. Mr. McDonald, board members, I have approved this being a teleconference type hearing, electronic hearing. I would advise council and the folks that are remote that you need to be very close to the microphone, very close. And if we can't hear, that degrades the quality of our understanding of your case and may affect your case. Just wanted to make sure you're advised of that. Mr. McDonald.
Thank you, Mr. Chairman. And again, on behalf of CCI Paradox, I would like to thank you and the board for accommodating them to testify electronically from their headquarters in Houston. Hopefully you won't be hearing anybody state those famous words, Houston, we have a problem today. So we do thank you. Testifying today, as you can see on your screen, will be 3 witnesses from CCI. We have Ms. Anna Hudson, the landman. We have Mr. Mark Andreasen, the Vice President of Geoscience. We have Mr. Kevin Neely, the Vice President of A&D Reserves and Reservoir. At this time, I would ask that they be sworn in.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Will you individually, did all of you say yes?
Yes.
Thank you.
Yes.
Let the record show that all the witnesses said yes. Back to you, Mr. McDonald.
Thank you, Mr. Chairman. The resumes of all 3 witnesses were submitted as part of Exhibit A in this cause. All 3 are testifying before the board for the first time. Ms. Hudson will be testifying as a fact witness only, but if all 3 were separately and individually asked about the contents of their respective resumes, they would confirm the same. It is my understanding that based on Exhibit A that the division will stipulate to recognizing Mr. Andreasen and Mr. Neely as experts in geology and petroleum engineering, respectively.
That's correct. The division does not object as long as on direct you can provide a brief statement of their expertise in this field, this particular area.
And we will do that, Mr. Chairman.
Okay.
All right, thank you. I also want to confirm that the board received the supplement to Exhibit Z on Monday. That's just the additional mailing receipts.
Yes, we did.
Thank you. And again, Mr. Chairman, as typical, I will be moving for admission of our exhibits at the end of my presentation.
That's our preference.
Thank you. Members of the board, CCI operates the Middle Mesa Federal Unit in San Juan County. The unit has contracted down pursuant to the terms of the governing unit agreement to 2 participating areas, but only the 5th revised Hermosa Group Consolidated Participating Area A is relevant to this cause. CCI is also the lessee under United States Oil and Gas Lease UTU 77538, which because of the unit contraction covers lands both within and outside of the unit. In August of 2014, CCI spud the Middle Mesa 26-23-2924 well at a surface hole location within the unit, directionally drilled it to a bottom hole location outside of the unit, but with the entire wellbore upon lease UTU 77538. The well was completed as a producing gas well on November 3rd, 2014, but its first production was on October 1st, 2014. The productive intervals of the well are all within the Hermosa group, but are also within and outside of the unit. Under these circumstances, the Bureau of Land Management regulations and guidelines require communitization, under which the agreement is to allocate production on a pro rata acreage basis to the portion of the leasehold outside of the unit and to all of the production interest owners inside the unit participating area. However, the BLM will not approve a communitization agreement without a conforming spacing order from this board, the reason CCI is before you today. As the testimony and evidence we'll offer today will reflect, the Hermosa Group constitutes one common source of supply, and the well will not drain more than 20 acres, being the southeast quarter, northwest quarter of Section 26, which are the lands outside of the unit, and the southwest quarter, northeast quarter of Section 26, which are the lands inside of the unit. Consequently, CCI seeks establishment of those 20 acres as a special drilling unit for this well. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5 subparagraph 3B and 40-6-6 subparagraph 6. The request was sent via certified mail return receipt requested to the BLM, both the state and Moab district offices, as the governing agency and an oil and gas owner, and to all of the production interest owners in lease UTU 77538 and in the unit participating area. They were sent to their last addresses as disclosed by a search of the agency records and the San Juan County Realty records. CCI is the only operating rights owner in both the PA and outside the unit. Notice of the request in this hearing was also published in the San Juan Record on March 2nd, 2016, the Moab Times Independent on March 3rd, 2016, and in the Salt Lake Tribune Deseret Morning News on March 6th, 2016. The Utah State Office of the BLM timely filed a letter with the board on February 29th, 2016, expressing its support for the granting of the request. To the extent that letter is not already deemed a part of the record, Mr. Chairman, we would request that the board include it at this time.
The division does not object.
Board members? So admitted.
Thank you. No other objections or responses were filed, and the division elected not to submit a staff memorandum in this particular cause. With that, I'll commence my examination of Ms. Hudson. Again, Ms. Hudson, a reminder to please speak directly into the mic so that everybody can hear you. Would you please state your name and business address for the
Can I
record?
interrupt just 1 second? We're getting some background noise. Is there a door open or a window on the Houston end that would account for that background? Okay. All
My
right.
name is Anna Hudson. I'm a
Okay.
man at
Sounds
CCI
good.
Paradox Upstream.
That has improved the sound. Thank you.
Okay, could you repeat that, please, Ms. Hudson?
My name is Anna Hudson. I'm a landman with CCI Paradox Upstream in Houston, Texas.
And
You're not close enough to the mic, ma'am. We're not hearing you.
okay, would you try again, please, Anna?
My name is Anna Hudson.
Much better.
Okay. My name is Anna Hudson. I'm a landman with CCI Paradox Upstream in Houston, Texas.
Do your areas of responsibility include the Middle Mesa unit and the surrounding area?
They do. I'm responsible for all upstream and midstream Paradox assets held by CCI.
Okay. Since this is CCI's first appearance before this board, could you give the board just kind of a brief overview of the company and its history here in Utah?
Of course. CCI is an affiliate of Castleton Commodities International. Castleton was formerly known as Louis Dreyfus Highbridge Energy, which was the energy subsidiary of the Louis Dreyfus, one of the world's leading commodities companies with a 160-year history. CCI owns and operates upstream and midstream assets in the Four Corners region of Utah and Colorado. These assets consist of over 180 oil and gas wells and approximately 88,000 net acres of mineral leases, providing a significant proved reserve space, as well as a midstream gas processing facility and 262 miles of gas gathering systems. These Paradox assets were acquired from Patara Oil and Gas, LLC in 2013.
Okay, thank you. Could you also, for the record, state what is the corporate and bonding status of CCI?
CCI is a Delaware limited liability company in good standing with its principal place of business in Houston, Texas. CCI is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all relevant federal and state of Utah agencies.
Thank you. Would you please provide a brief history and the status of the Middle Mesa unit?
The Middle Mesa unit was originally formed in 1998 and covers all formations. This unit originally included all of lands covered by lease UTU 77538, but contracted down to its participating areas, the largest of which involves the 5th revised group Consolidated Participating Area A, the southeast quarter of the southeast quarter of the northwest quarter of Section 26 was contracted out of the unit. CCI is currently the operator of this unit.
Okay, Ms. Hudson, I'm going to ask you to refer to what have been marked as Exhibits B and C for purposes of those cause. Do you have those exhibits in front of you?
I do.
And were those exhibits prepared by you or CCI personnel with your review and input?
they were.
Okay, directing your attention now to Exhibit B, which is a two-page exhibit. The first page is shown on the PowerPoint here in Salt Lake. Would you please explain to the board what this represents?
This is a general reference plat reflecting the location of the Middle Mesa unit and the proposed drilling unit. It's southeast of Moab and about 4 miles due south of the town of LaSalle.
Yes, if you could repeat that and slow down a little bit for the court reporter. The
And-
mic's kind of cutting out a little bit, so again, you
And
have
you're
to be
cutting
right
out
close
on the
to it.
recorded part of this. We're just going to have to insist that you move the mic as close as humanly possible. So you need to be a lot closer to that mic to have it work for us on this end.
It'll also help, Anna, if you slow down a little bit. That way it won't cut out as much either.
Okay. So the first page of Exhibit B is a general reference plat reflecting the location of the Middle Mesa unit and the proposed drilling unit. It's just southeast of Moab and 4 miles due south of the town of LaSalle.
Okay, now directing your attention to the second page of that exhibit. Please explain to the board what this is.
This is a zoomed-in view of the proposed drilling unit, which is in the purple box, and also includes the surface and bottom hole location of the Middle Mesa 26, 23, 29, 24 well. The red star or circle indicates the bottom hole location. The black circle indicates the surface.
All right, thank you. Now directing your attention to Exhibit C. Would you please explain to the board what this represents?
This is a zoomed-in view of the proposed drilling unit relating to the Middle Mesa unit and the fifth revised Hermosa Group Consolidated Participating Area. Please note that lease UTU 77538 covers the entire drilling unit. Allocation within the unit would be allocated on a pro rata acreage basis over the entire participating area. The drainage circles in the center will be discussed in further detail by Mr. Neely, but just note at this time that they extend both inside and outside of the unit. We are the only operating rights owner in this unit and the lease.
And just for clarification, the purple box is the proposed drilling unit, is that correct?
That is correct.
And the blue boundary is the boundary of the unit in the participating area, is that correct?
That is correct.
All right. Would you please provide to the board a brief history of the Middle Mesa 26, 23, 29, 24 well?
The Middle Mesa 26, 23, 29, 24 well was spud on August 11th, 2014. It was drilled directionally and completed as a producing gas well with first production on October 1st, 2014. The producing intervals
Hold
are
on,
within-
Anna, hang
Yeah,
on a
one
second.
second.
You're still cutting out a little bit, so if you could, again, just get as close to the mic as you possibly can and speak slower. Sometimes it's the Skype, too.
Okay. The Middle Mesa well was spud on August 11th, 2014. It was drilled directionally and completed as a producing gas well with first production on October 1st, 2014. The producing intervals are within the Hermosa Group, but are also located in and outside of Middle Mesa unit.
Okay, now I'm going to ask you to look at Exhibit D, what has been marked as Exhibit D for this cause. There's no PowerPoint for this for the board. Do you recognize Exhibit D?
I do.
And was that a official business record of CCI that you received?
It is.
Okay, would you please explain to the board what that represents?
This letter was received by CCI Paradox upstream from the BLM, indicating that because the 26, 23, 29, 24 well has producing intervals both inside and outside the unit, CCI must either expand the unit to include the producing lands outside the unit or arrange for a communitization agreement, CI. However, a conforming order from the board establishing a drilling unit is required prior to the agency's approval of a communitization agreement.
Okay, how will this order affect correlative rights of the parties?
The requested order is required to protect the correlative rights of the parties, both inside the participating area and in the lease, insofar as it covers lands outside of the participating area. The effective date of this order should correspond with the date of construction, being October 1st, 2014. Not only as a matter of equity and fairness, but also because BLM guidelines so require.
And would you please confirm for the board that CCI will pay the proceeds retroactive based on whatever the order is from the board?
Correct. CCI will retroactively pay production proceeds as ordered by the board.
Okay, now I'm going to direct your attention to one of the pleadings that's in this matter. It's the certificate of mailing. Do you have that in front of you?
I do.
All right, and this was a pleading that's already on file prepared by the office. Do you recognize the names and the addresses of the parties listed on that pleading?
I do. It's a list of all the government agencies with jurisdiction over and all the production interest owners within the subject lands, including all production interest owners in the participating area. It was compiled from business records, searches of BLM, SITLA, and San Juan County Realty records.
All right, and directing the board to Exhibit Z is supplemented. These are true and correct copies of the return receipts or return mailings received by my office of the mailing of the original request. It was supplemented on Monday to reflect the receipts returned after the exhibit filing date. Mr. Chairman, that concludes my examination of Ms. Hudson.
Thank you. Division?
Mr. John Rogers does have a question for this witness.
Proceed.
John Rogers with the division. The southeast northwest quarter, section 26, was contracted out of the unit in October 2013. What was the purpose of this, or what drove that decision?
The unit underwent a contraction after this well was drilled, but it was retroactive back to 2011. So at the time, this acreage would not be included in that contraction.
Yeah, and the ownership, I see there are 3 leases covering the current unit. Those outside, are they still owned by CCI, or are those other owners in those leases?
The leases you can see on Exhibit C are owned by CCI. There are some leases within the Middle Mesa participating area where CCI does not own 100%. We operate that unit with a 99.6% working interest.
The area in question, are you 100% working owner?
Yes.
No further questions.
To the board, any questions of this witness? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. Okay, Mr. Andreasen, again, just a reminder to please speak as closely to the mic and slowly, just so that the court recorder is picking up everything. Would you please state your name and business address for the record?
My name is Mark Andreessen. First, can everyone hear me okay?
Just a little closer.
A little closer, okay. My name is Mark Andreessen. I work for CCI, business address of 811 Main Street, Houston, Texas, 77002.
All right, and what is your current position with CCI?
I am the Vice President of Science, which includes all of CCI's Paradox assets, including the Middle Mesa unit.
Okay, to satisfy the division's requests with respect to your recognition as an expert in geology, could you please give a brief summary of your experience either in the Paradox Basin or analogous basins?
Yes. I hold both a Bachelor and Master of Science degrees in geology from the University of Texas in Austin. I have been working the Paradox Basin for the past 5 months with CCI, but I also have extensive experience in similar mixed carbonate clastic shallow marine depositional environments in U.S. basins such as East Texas, the Gulf Coast, Michigan Basin, Illinois Basin, and in North Texas.
Thank you. Directing to the division, is that satisfactory to your inquiry?
It is.
Thank you.
Thank you.
Board members? Any questions about the, okay. Do you want to admit him as
Would
an
he
expert
be,
for the
yes, at
purposes
this
of
time,
this?
Mr. Chairman, is it appropriate to have the board formally recognize Mr. Andreessen as the expert in geology?
So noted.
Thank you. All right, Mr. Andreessen, would you please provide a brief overview of the depositional nature of the Hermosa Group?
Yes, the Hermosa Group, which is made up of the Hanukkah Trail sandstones and the LaSalle member carbonates, are all deposited in a shallow marine setting. The LaSalle carbonates are, again, more marine. As we grade to the top of the Hermosa Group, they become increasingly non-marine and fluvial.
Thank you. Now, I'm now going to direct your attention to what have been marked as Exhibits E, F, and G for purposes of this cause. Do you have those exhibits in front of you?
Yes.
Were they prepared by you or CCI personnel with your review and input?
Yes.
Okay, directing your attention to Exhibit E, this is a two-page exhibit. The first page is now shown on the PowerPoint for the board. Would you please explain what the first page represents?
The first page marked Exhibit E is a type log showing the thickness of the Hermosa formation, which in this location is approximately 1,650 feet thick. You see the location of the LaSalle limestones at the base of the formation, grading upwards into the various Hanukkah Trail sandstones, which are marked HATR numbers 1 through 5 on Exhibit E.
All right, and this was the type log that was used for the stratigraphic definition of the Hermosa Group as set forth in the request. Is that correct?
Yes.
All right, turning your attention now to the second page of Exhibit E, would you please explain what's important from this exhibit for the board?
On this exhibit, it shows what are the active perforations or the open perforations in the well that are relevant to volumetric calculations, and circles that are shown on Exhibit C.
Okay, directing your attention now to Exhibit F, would you please explain to the board what this represents?
Exhibit F is a structure map at the top of the LaSalle limestone member. What's noted is it is a faulted three-way structure dipping from the southwest to the northeast. Also noted is a location what's now called the LKO. This defines the position of the lowest known oil on the LaSalle member. It provides no material significance for the purposes of this cause.
Okay, could you repeat that again? The court reporter in the Skype kind of froze up a little bit. So again, if you could repeat that about the LKO.
No problem. Exhibit F is a structure map on the top of the LaSalle carbonate member, and what it shows is a faulted three-way closure that dips from the southwest to the northeast. The location of the green dashed line, known as LKO, refers to the lowest known oil position at the LaSalle carbonate level, but it serves no material significance for the purposes of this cause.
Okay, so it's simply noted on here, but it really doesn't have a relevance to what you're asking for today. Is that correct?
Yes.
Okay. Directing your attention now to Exhibit G, would you please explain what this represents?
Exhibit G is a cross-section that is noted on the green solid line on Exhibit F shows the position of this cross section, and this is only to show the consistency of the Hermosa group producing intervals across the Middle Mesa unit area.
And that word was Hermosa? Is
Yes,
that
sir,
correct?
Hermosa.
Thank you.
All right, thank you. Okay, so then, in your expert opinion, is the defined Hermosa group, does it constitute a common source of supply for gas and associated oil and hydrocarbons?
Yes, it does.
Thank you. That concludes my examination of this witness, Mr. Chairman.
Thank you. Division?
No questions of this witness.
Board members?
Could you describe just briefly the rationale for drilling this well directional in the place that it's in?
I will try to address that. This well was drilled before my employment with CCI, so I had no role in the location or the determination of the well path. My assumption would be for the only reason why a directional well would be drilled on this unit would be there's obviously a surface obstruction that had to be that a surface location to drill a vertical well could not be positioned on this location, or the fact that again there is a fault cut here and they were trying to maximize the number of intersection of the number of producing zones intersected by the path of the well bore. Again, since I was not employed by CCI at the time of the drilling of this well, I can only guess it be one of those two reasons.
Thank you.
Other questions of the board? Back to you, Mr. McDonald.
Thank you, Mr. Chairman. If you'd pass the mic over to Mr. Neely. Mr. Neely, again, as you've heard, please keep the mic as close as possible so that it comes through clearly, and speak slowly, and it'll help in case there's things mixing with Skype, okay?
Okay, I will.
All right. Would you please state your name and business address for the record?
My name is Kevin Neely, and I work in the Houston headquarters here for CCI. We're at 811 Main Street, Houston, Texas, 77002.
And what is your current position with CCI?
I am Vice President responsible for reservoir engineering, reserves, and acquisitions and divestitures.
All right. Again, to satisfy the division's request to have you qualified as a petroleum engineer, would you please address your experience in the Paradox Basin or analogous basins?
Yes, I've worked for CCI for about 6 months, and I've been responsible for Paradox Basin assets for that entire time. We've done the reserve report for that and also done some technical work on our other properties up in that area. I think similar to Mark, I've had a career that's spanned various U.S. basins that are somewhat similar in nature. They're mixed carbonate clastic settings that would be analogous or similar to what we see in the Paradox.
Does that satisfy the division's inquiry?
Yes, thank you, it does.
Mr. Chairman, at this time, I would ask that Mr. Neely be recognized as an expert in petroleum engineer for purposes of this cause.
Division?
No objection.
Board members? He's so admitted as an expert for purposes of this hearing.
Thank you, Mr. Chairman. Mr. Neely, if you would please look at Exhibits C and H. Do you have those exhibits in front of you?
I do.
All right. Were they prepared either in whole and part by you or CCI personnel with your review and input?
They were.
Okay. Directing your attention to Exhibit H, which is shown on the PowerPoint for the board, would you please explain what this represents?
Yes, Exhibit H shows the calculations where we calculated the drainage acres for each of the perforated intervals in the 3 Honecker Trail intervals that are perforated, and also the lowermost interval, which is the LaSalle carbonate. We used information, historical production information to get our oil cum to date, and then also a forecast of future production to get an estimated ultimate recovery. We had data that was input from wireline logs, a repeat formation tester that had been run the well, and also as we just go across the exhibit, we go through a calculation where we input our calculated parameters from the logging, operation, porosity, water saturation. We calculate our SGVH. We assumed a recovery efficiency of 65%, which we think is reasonable for this type of reservoir. We have an allocated net pay in the next column, and then we go all the way across to our drainage radius for each interval, the largest of which is 6.5 acres.
All right, so moving on then, going back to Exhibit C, can you relate those calculations then to what's depicted on Exhibit C?
Yes. What we have done then is plotted each one of those drainage circles relative to the perforated interval, and as was mentioned earlier, this is a directional well, so it's not vertical or not completely horizontal, but we've got each drainage circle plotted relative to reference to its proper interval in the wellbore where the perforations are at.
So essentially, this is a visual representation of what's depicted on Exhibit H.
That's correct.
All right. So is it your opinion that no more than 20 acres would be drained by this well?
It is. That is my opinion.
Okay. And would a 460-foot setback from the well and the drilling unit prevent communication with other wells?
Yes, it would.
Okay. So again, in your expert opinion, based on the data generated to date, is the proposed well not smaller than the maximum area that can be economically and efficiently drained by the well?
Yes.
Thank you. Mr. Chairman, that concludes my examination of Mr. Neely.
Thank you. Division,
Mr. Doucette does have one question.
proceed.
Yeah, I'm not sure if I've heard this in the testimony yet. On Exhibit C, could you explain the allocation of production on this well?
Yes, we allocated the production. Actually, if you look at Exhibit H, kind of in that left-hand side that starts with the perforated height, and then we allocate actually SGVH based on the net pay interval, the porosity, and the SW, and then we do the production allocations based on each perforated intervals SGVH to come up with an allocation of net pay, and then a original gas in place, if you look at the second column, all the way to the right, to come up with a drainage acres for each interval.
So that's just the allocation of what production is coming from each interval, correct?
That is correct. It's the production that has occurred to date plus the forecast production in the future.
So how will you allocate that to the participating area versus the lease?
That might be a better question for Ms. Hudson.
Okay if Ms. Hudson answered that?
Yep.
Proceed.
According to BLM regulations, it will be allocated on a pro rata acreage basis. In this case, 50% of the acreage being contributed to the spacing unit is in the unit, and 50% will go to the lease, and that's how proceeds will be allocated.
Okay, thank you.
Has the BLM determined that this well is in paying quantities to be accepted into the unit?
Has not been a paying quantities determination.
Is that plan be in the near future, or how does that work?
No, because this we're doing this spacing, and then we will communitize, and so this well will not be part of the unit. It will be what's considered a lease well, not a unit well.
Okay. That leads me to another question. The BLM gave you two options, either to seek expansion of the unit or to go get a communication agreement after spacing. After this well is possibly been spaced, will you seek to expand the unit?
No, we'll seek a communitization agreement from the BLM to satisfy their request.
And why did you seek option number 2 versus option number 1?
That was done after Mickey Coulthard of the BLM let me know that his preference would be for us to space it and communitize.
Thank you.
Okay. Questions from the board for Mr. Neely? Go ahead.
Just a question back on Exhibit C, I'm sorry.
Okay, we're at Exhibit C.
I just wanted to hear the explanation
A
again.
little closer to the mic, please.
Hear the explanation again as to why the circles were enlarged the deeper you went.
Yeah, it actually relates to the reservoir properties of each interval, and it's assigned SGPH and then the allocation of original gas in place for each interval. So it's just simply a calculation that with those reservoir properties and with that pay footage, we have to drain 6.5 acres to get out that assigned amount of oil and gas out of that interval.
Okay, thank you.
I have some questions, Mr. Neely. Would you go to Exhibit H?
Yes.
My questions are directed to understanding this, and they may also fall under the category of just educating me. I don't see where you have put in permeability quite like I thought you would in this. Would you just guide me through that a little bit?
Yeah, the only permeability measurements that we have on this well, strictly from wireline logs, we can't get permeability. We don't have any hole or sidewall core data on this well. We did have some repeat formation tester data that showed that the lowermost interval, the LaSalle carbonate, had higher permeability than the 3 Honecker trail intervals. But for this calculation, we don't really need to use permeability in this. It just simply assumes that each interval is reallocate the fluids to each interval, and then each one will drain its assigned area. These drainage areas are actually fairly modest in here. This well has fairly modest recoveries. If we had good permeability data, preferably from core data, we could have done maybe a little bit more to fine-tune this, but I didn't really trust the perm data that we would get from the repeat formation tester.
Okay, follow-up question is you've used the term recovery efficiency as a %. How does that differ from recovery factor? Is that the same thing?
I'm using it as one and the same.
Okay.
That's correct.
Thank you. That's all the questions I have. Okay, we're back to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation in chief. At this time, I would move for admissions of Exhibits A through H and Z as supplemented.
No objection.
Board. Exhibits A through H, Exhibits Z and supplement to Z are admitted.
Thank you, Mr. Chairman. With that, I would like to reserve just a closing statement after the division's presentation.
We're now to the division.
The division does not have additional presentation and supports their request.
Okay, let the record show the division supports the request. We're back to you, Mr. McDonald.
Thank you, Mr. Chairman. Again, the board has heard several of these matters over the past few months where these wells within unit areas require communitization agreements, and this is a similar situation. It is a little unique in that the well bore is both inside of a unit and outside of a unit. But again, this is a requirement that's mandated by the Bureau of Land Management. This is their stated preference of the method to going forward, and so we believe that all the statutory and regulatory requirements for granting the request as submitted have been met, and we would ask that the board grant the request as submitted.
Thank you. Board members, we can retire to discuss this, or a motion would be in order.
I move that we approve this request.
Second. Any discussion? Seeing none, the motion before you is to approve the request for agency action as submitted. All in favor say aye.
Aye.
Any opposed? Let the record show that was unanimous. And that concludes agenda item number 3. Mr. McDonald, will you prepare the order?
I will, Mr. Chairman. And again, thank the board for the allowing our clients to participate remotely. And I'd also like to acknowledge Paul's help from the division again to set this all up.
Thank you. Appreciate your comments. With that, board members, that concludes our formal matter today. We do have some discussions that we'll be taking care of. A motion to adjourn would be in order. The motion before you is to adjourn. All in favor say aye. We are adjourned unanimously. Thank you.
Thank you, Houston.
Thank you.
And I'll
In
call you
Houston.
later.